when you have laws and regulations, sometimes you'll get regulatory agencies, state, federal, or otherwise, that enforce these rules, these laws, these standards. Sometimes you'll get private litigants that, try to attack gaps, enforcement gaps. There are things, restrictions on private rights of action. So for example, the US Food and Drug Administration, my former employer, one of the laws that they enforce, the Federal Food, Drug, and Cosmetic Act, does not have a private right of action. You cannot sue someone for failure to meet the standards in the FD&C Act, the Federal Food, Drug, and Cosmetic Act. However, there's always a however. States like California have adopted the Federal Food, Drug, and Cosmetic Act as a state law, with one very, very big additional point, which is that the Sherman Act in California, their Food and Drug and Cosmetic Act, has a private right of action, right? So if you're dealing in California, you know that you can essentially be sued for violating what is almost identical to the Federal Food and Drug and Cosmetic Act. Getting ahead of myself, we will talk about what that means in a few minutes, but some agencies to know about. We already talked about the FDA. They regulate a number of things, but in this space, foods, food additives, dietary supplements, bottled water, and infant formulas. I've heard a lot about infant formula over the past year or so. U.S. Department of Agriculture regulates aspects of safety and labeling of traditional, so non-game meats, poultry, and certain egg products. The Federal Trade Commission has somewhat of an overlay. As its name suggests, it regulates trade and consumer protection. So unfair, deceptive trade practices, fraudulent practices, this can be everything from you don't have substantiation to you engaged in an auto renew program, a subscription program without adequate disclosure, or, you cherry picked reviews for your products and you only highlighted the positive reviews. So the FTC and the FDA and USDA, they work together. I like to think of FDA and USDA as regulating the product itself, whereas the FTC will regulate the advertising, the substantiation. There's also a self-regulatory body to know about, which is the National Advertising Division of the Council of Better Business Bureaus. It's just easier to call it NAD, but I don't like to use acronyms before I define them. And so the NAD is an organization that industry becomes a part of voluntarily, but there is a case resolution process within the NAD, and competitors, they'll file a complaint against a fellow industry participant, and the NAD will look at the facts. There's different case types. We don't need to get into that today, but I'm of course happy to address that with you offline if you're interested. The bottom line is, you might say, well, what's the big deal? It's a self-regulatory body. Company could just leave that body if they wanted to. Well, here's the big deal. Once you consent to being part of that resolution process, once the NAD issues its ruling, if you do not comply with the ruling, you're the competitor that was taken to task for some maybe unsavory advertising practices. If you do not comply with the NAD's order, decision, case resolution, NAD has a history of referring matters to the Federal Trade Commission. So it's voluntary until it's not voluntary, if you understand what I'm saying.